When you're being questioned at a pretrial question and answer session known as a deposition during your medical malpractice or accident case, how do you know if it's okay to go ahead and answer a particular question? You want to know the answer? Come join me on this walk through the neighborhood as I share with you that exact answer. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. During the course of your lawsuit, the attorney who represents the people whom you have sued will now have an opportunity to question you, to learn from you, in your own words, exactly what happened and what injuries you have and those things you can and cannot do each and every day. All right, so now during the course of this questioning, which by the way takes place in your attorney's office, there's no judge present, there's no jury present, it's just the defense lawyer, your lawyer, and a court stenographer who is there to record all of the questions you are being asked and all of the answers that you give. So now, during the course of this questioning, which by the way can go on all day, how do you know that it's appropriate for you to go ahead and answer certain questions? I'll tell you how. If you hear during the course of questioning your attorney yell out, "Objection!" then you have to stop and not answer the question until you get instruction from your attorney about whether or not you can go ahead and answer that question. But if you don't hear your attorney object, then you go ahead and answer the question. Now you might be thinking, wait a second, there are some instances where you may think that the question is inappropriate, or you don't want to give an answer to a particular question. Do you still have to go ahead and answer the question? The answer is, yes, you do. This process is known as discovery. The defense has an opportunity to learn a lot of information about you. It doesn't mean that if your case goes to trial, they'll actually be able to use all of that information. Instead, they are entitled to discover a lot of information that you think is not appropriate or related or relevant to the particular facts of why you brought this lawsuit. And that is true. So now you have this thought in your mind, why do I have to answer this question if it's got nothing to do with the facts of this case or with what the doctor is arguing as a defense in this case? And the reality is it's discovery. So if your attorney believes that it's an inappropriate question or a question that should not be answered, then your attorney will definitely pipe up and say, "Objection!" And either he'll say, "Don't answer that question," but he can only do that in very limited instances, or he'll say, "Objection, go ahead and answer that question." Now you might be thinking, wait a second, why is he objecting and telling me to go ahead and actually answer the question? Because he probably thinks that there's something wrong with the question. Maybe it's the way it's phrased, maybe there's something improper, maybe it's unrelated to the issues in this case. And now, for the record, he's noting his objection to this question, but he is still telling you to go ahead and answer that question. You should know that in New York, there are really only two instances where you do not have to answer the question. So the defense attorney turns around and says, "Hey, Mrs. Jones, tell me what you and your attorney spoke about before I started questioning you." Objection! That's confidential and privileged information. You are not to answer that question. So the attorney would be well within his right to say that and for you not to answer the question. The other time where it's totally appropriate for your attorney to object and tell you not to answer the question is when something is so off the wall crazy, and now it's so bizarre, we call it palpably improper. So, for example, in a medical malpractice case where you claim that your doctor did something carelessly, causing you significant harm and injury, and he turns around and says, "Mrs. Jones, how many times did your husband beat you each night?" What? What does that have to do with anything? I object. That is palpably improper. I direct you not to answer that question. Now, as I'm thinking about this, in a wrongful death case, there is another instance where it would be totally appropriate for your attorney to object and tell you not to answer the question. So in a wrongful death case, sometimes the defense attorney turns around and says, "Hey, Mrs. Jones, how much life insurance did your husband have before he died?" Objection. I direct you not to answer that question. That's a totally inappropriate question because that has nothing whatsoever to do with whether or not your client, the doctor, is actually responsible for what happened, nor does it have anything to do with the amount of money he's going to be required to compensate the surviving family as a result of the doctor's carelessness. So whether he had $1 in life insurance, no life insurance, or $5 billion in life insurance makes no difference because this guy is going to be held accountable for his own actions, and ultimately a jury will have to decide how much money they are going to compensate you as the surviving spouse for all of the harms and losses and financial damages you suffered because of this doctor's carelessness. So why do I share this with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit, but are thinking of doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.